Good day, sir. I'm Senit Anaros, BSCRIM 4B. These are my discussion about the rules of the criminal procedure. Rule 110. Prosecution of offenses under the Philippine Rules of Criminal Procedure outlines the rules governing the initiation and the prosecution of criminal cases. It specifies how offenses are charged, who may prosecute them, and, and the procedures for filing complaints or informations. First is commencement of criminal actions. In Section 1, a criminal actions are commenced by filing a complaint or information with the proper court. Complaints are typically filed with the prosecutor's office or in certain cases, directly with the court. Second, who may file the complaint. In Section 3, any offended party, peace officer, or public officer charged with the enforcing the law may file a complaint. Third, contents of a complaint or information in Section 6 must state the following: name of the accused or description if unknown, designation of the offense by statute, acts or omission constituting the offense, name of the offended party, and approximate time and place of the offense, and other relevant facts for proper understanding. Fourth, prosecution of criminal actions. In Section 5, generally all criminal actions are prosecuted under the direction and control of the public prosecutor. However, in private crimes, adultery, concubinage, the offended party must initiate the action. Fifth, amendment of the complaint or information. In Section 14, complaints or informations may be amended before, before the accused pleads without needing court approval. After the plea, but only with the court approval, provided no prejudice is caused to the accused. Number 6, offenses requiring private prosecution. In certain offenses like defamation or violation of family rights, the aggrieved party must actively participate in the prosecution or file the complaint themselves. The purpose and importance of Rule 110 to ensure clarity and sufficiency in charging the accused, protects the accused's constitutional right to be informed of the nature and cause of the accusation, regulates the conduct of criminal prosecution to uphold justice and fairness. Rule 111, Prosecution of Civil Action in the Philippines. Rules of Criminal Procedure governs the interplay between criminal and the civil actions arising from the same offense. It provides rules on how the civil liability of the accused stemming from a crime can be pursued. First is implied institution of civil action in Section 1. When a criminal action is filed, the civil action for the recovery of civil liability is generally then instituted along with it, unless the complainant expressly waives the civil action, reserves the right to file it separately or files it ahead of criminal case. This rule ensures efficiency and avoids duplicative allegation. Second, reservation to file civil action separately in Section 1. The complainant may reserve the right to pursue the civil action independently. This reservation must be made before the prosecution starts presenting evidence in the criminal case. And the third, independent civil actions in Section 3. Some civil actions, like those based on Articles 32, 33, 34, and of the Civil Code, may be filed independently regardless of the criminal case. These actions include cases for violation of the civil rights, defamation, fraud, or negligence. Fourth is effect of the criminal case on the civil action in Section 2. The civil action is suspended if the criminal case is filed first, except when the civil action is independent. The outcome of the criminal case can affect the civil action. For example, the acquittal, due to absence of a crime, generally extinguishes the civil liability. Acquittal on reasonable doubt does not necessarily extinguish civil liability. Fifth, consideration of civil and criminal action in Section 1. The civil action can proceed alongside the criminal case if filed together, promoting judicial economy. The purpose of Rule 111 aims to balance efficiency and fairness in resolving both criminal and civil liabilities arising from the same act or omission, ensuring that the aggrieved party is compensated while maintaining procedural clarity. Rule 112, Preliminary Investigation. Under the Philippine Rules of Criminal Procedure, governs the process of determining whether there is probable cause to file a criminal case in court. It ensures that the accused is not subjected to the trial without sufficient evidence and safeguards their constitutional rights to due process. Definition of preliminary investigation. A preliminary investigation is an inquiry or proceeding conducted to determine whether there is sufficient ground to believe that a crime has been committed and, and the respondent is probably guilty and should be held for trial. It is not a trial but process to filter cases to prevent groundless prosecution. 2. Who conduct the investigation in Section 2? Preliminary investigations are conducted by authorized officers such as provincial or city prosecutors, their assistant state prosecutors, or other officers authorized by law. Third, when preliminary investigation is required in Section 1, it is required for offenses punishable by imprisonment of at least 4 years, 2 months, and 1 day, without considering the fine. And the fourth is steps in preliminary investigation in Section 3, filing of the complaint. The complaint is supported by affidavits and evidence. Issuance of subpoena. The respondent is given a chance to submit a counter affidavit and evidence. Evaluation of evidence. The investigating officer evaluates all evidence submitted. Resolution if probable cause exists, the prosecutor files an information in court. If none, the complainant is dismissed. And the fifth is resolution period in Section 3. The investigating officer must resolve the complaint within 10 days after the investigation ends. And review of resolution, Section 4. The aggrieved party can appeal the resolution of the prosecutor to the Secretary of the Justice or file a motion for reconsideration. 7 is exception to preliminary investigation. Arrested individuals in valid warrantless arrest may be charged directly in court, and a preliminary investigation may follow only after the case is filed. The purpose and importance of Rule 112 prevents frivolous and malicious cases, protects individuals from unnecessarily litigation and detention, balances the need for prosecution with the rights of the accused. Rule 113 of the Rules of Court in the Philippines outlines the procedures and rules regarding arrest. It specifies and how when a person can be taken into custody by law or other authorized individuals. Arrest is taking of the person into custody that he may be bound to answer for the commission of an offense. Arrest made by an actual restraint of a person to be arrested or by his submission of the custody of the person making the arrest. When can be person be arrested? There are 2 scenarios for arrest. The first is with a warrant. Section 3, a judge issue an arrest warrant based on probable cause. After evaluating evidence, the warrant gives law enforcement the authority to take the person into custody. And number 2, without a warrant in Section 5, an arrest can be made without a warrant in the following situation. In flagrante delicto, caught in the act, when the person is caught committing, about to commit, or has just committed a crime. Hot pursuit when the officer has personal knowledge of facts indicating that the person just committed a crime, or escape with the person escape from the from the custody, or is a prisoner fleeing after conviction. How is an arrest warrant served? The officer must show the warrant and inform the person of the reason for the arrest. If the arrest is made without a warrant, the person must still be informed of the reason and the rights of the person arrested. First is the right to be informed of the reason for the arrest. The officer must clearly explain why the arrest is being made, and 2, the right to counsel and remain silent. The person cannot be forced to confess or speak without a warrant, without a lawyer. Number 3, right against illegal detention. The arrested person must be brought to a court or prosecutor without unnecessary delay, generally within 12 to 36 hours depending on the penalty of allied offense. Duty of the arresting officer. After the arrest, the officer must first is deliver the arrested person to the nearest police station or detention facility. Number 2, file a complaint with the appropriate court or prosecutor within the prescribed time. Citizens arrest, even private citizens can arrest someone without a warrant if the crime is committed in their presence. They are chasing someone who just committed a crime. Legal safeguards. Arrest must comply with legal procedures to avoid accusations of illegal detention or abuse of authority. Any arrest that does not follow the law can be challenged in court. The importance of Rule 113 to protect individuals from unlawful arrest and to ensure the law enforcement follows due process and balances public safety with individual rights. Rule 114 of the Rules of Court in the Philippines governs the concept of bail, which allows an accused person to secure temporary liberty while facing criminal charges. Bail is a security given by an accused person to ensure their appearance in court. When required, it can be in the form of cash, property, or a surety bond. The purpose of bail is to balance the right to liberty of the accused and the interest of justice, to ensure the accused attends court proceeding without being detained unnecessarily. Who can post bail? Any person under custody for a criminal charge can apply for bail, except in certain cases. Bail can be posted by the accused or another person acting on their behalf. There are the types of bail. The first is the corporate surety. A bail bond company guarantees the accused's appearance in court, and the second is property bond. Real estate is used as collateral for bail, and the third is cash deposit. The accused deposits money directly to the court, and the fourth is recognizance. The accused is released to a responsible person without monetary payment, usually for minor offenses or indigent persons. Bail can be granted first is as a matter of right in Section 4 for offenses punishable by imprisonment of less than 20 years. The accused can demand bail as a matter of right. This applies before conviction by the trial court. And number 2 is as a matter of discretion in Section 5 for offenses punishable by reclusion perpetua, life imprisonment, or death. Bail is not automatically granted. The accused must file a petition for bail, and the court will determine if the evidence of guilty is strong. Condition of granting bail. The accused must first is appear the court hearings, and the second is not commit another crime while on bail, and third is comply with all conditions set by the court. Denial of bail. Bail can be denied if the accused is charged with a capital offense, example, murder or treason, and evidence of guilt is strong, and the accused is considered a flight risk to or a danger to public safety. Cancellation or forfeiture of bail. Cancellation is bail may be cancelled if the accused violates the conditions of bail, failing to appear in court. Number 2, forfeiture. If the accused jumps bail, the court may confiscate the bail money or property. Right to bail. First is before conviction. The Constitution guarantees the right to bail except for offenses punishable by life imprisonment or death when evidence of guilt is strong. And the second is after conviction. Bail after conviction is discretionary and depends on how gravity of the offense and the likelihood of the appeal being meritorious. The importance of Rule 114 to protect the presumption of innocence and prevent unnecessary definition of the accused, and to ensure court attendance while safeguarding public interest. Rule 115 of the Rules of the Court in the Philippines enumerates the rights of the accused in a criminal prosecution. These rights are essential to ensure fairness, due process, and the protection of individual liberties. Rule 115 outlines the legal safeguards provided to a person accused of a crime to ensure they are treated fairly and justly during the trial process. These rights protects against abuse and guarantee due process. Rights of the accused in Section 1. First is right to be presumed innocent. The, the accused is considered innocent until proven guilty beyond a reasonable doubt. And this principle places the burden of proof on the prosecution. And second, right to be informed of the nature and the case of the accusation. The accused must be given clear and detailed information about the charges against them. This ensures they understand the allegations and can prepare an effective defense. And third is right to be present at the trial. The accused has the right to attend all court proceedings unless they waive this right or disrupt the process. The court cannot proceed without the accused in serious cases unless justified. Number 4. Right to counsel. The accused has the right to a lawyer of their own choice or court appointed if they cannot afford one. This ensures that the accused has proper legal representation. And the fifth is right to testify on their own behalf. The accused may choose to testify in court but cannot be forced to do so. Silence cannot be taken as an admission of guilt. And 6. Right to confront and cross-examination witnesses. The accused has the right to face their accusers in court, question prosecution witnesses to challenge their credibility. And 7 is right to compulsory process. The accused can compel the attendance of witnesses and the production of evidence through subpoenas. And 8. Right to speedy, impartial, and public trial. The trial must be conducted without unnecessary delays, ensuring justice is not denied by waiting, by an impartial judge and in a manner open to the public. And 9. Right to appeal. If convicted, the accused has the right to challenge the court's decisions in higher court. The importance of the rights. First is ensures due process, protects the accused from arbitrary or unfair treatment. Second, preserve fairness, guarantees that the trial is conducted in unbiased and transparent manner. Third, balances. Justice protects the accused while also allowing the prosecution to present its case. The practical application. Presumption of innocence means that even in high-profile cases, the accused cannot be treated as guilty until the court renders a judgment. The right to counsel ensures that even indigent defendants can adequately defend themselves. The right to confront witnesses prevents secret accusations, transparency in the trial. The limitations or waivers. The accused may waive certain rights, such as rights to be present or to testify, but this must be voluntary and informed. Rights are not absolute and must be exercised within legal boundaries. In Rule 1115 ensures that the criminal justice process is fair, impartial, and just, emphasizing the principle that everyone deserves a fair trial. These rights are critical in protecting individuals from abuse and wrongful conviction. Rule 116 of the Rules of the Court in the Philippines deals with arraignment and plea, a critical stage in a criminal case where the accused is formally informed of the charges and asked to enter a plea. Arraignment is the process where the accused is formally notified of the criminal charges and the accused is asked to enter a plea, guilty or not guilty. The purpose of arraignment is to ensure the accused understand the charges, to allow the accused to respond to the charges through a plea. It is a crucial step to ensure that the accused is right to due process. The provisions of Rule 116. First is when arraignment is conducted in Section 1, arraignment must take place within 30 days from the filing of the information or indictment in court, after the court acquires jurisdiction over the persons of the accused, and 2 is how arraignment is conducted in Section 1. The accused must appear in person, and the court then reads the information charged in a language or dialect the accused understand and asks the accused how they plead to the charge. Plea is a response of the accused to the criminal charge. It can be first is guilty. The accused admits to committing the crime. The court ensures the plea is made voluntarily, knowingly, and intelligently. If the penalty is severe, for example, reclusion perpetua, the court may require further confirmation. And two, not guilty. The accused denies the charge, leading to a trial. A plea of not guilty will also be entered if the accused refuses to plead. The court finds the accused plea improper, plea of guilty with mitigating circumstances, and the third is conditional plea, not recognized. Pleas that are subject to conditions such as plea bargaining are not allowed unless agreed upon. And fourth is plea of insanity, of mental incapacity. The accused may raise insanity as a defense, which is treated as a not guilty of plea. Rights during arraignment. The accused must be, first is be personally present, second have a lawyer present to assist them, and third is understand the charges and their plea. Motion to quash before arraignment. In Section 2, the accused can file a motion to quash the information or complaint before arraignment on grounds such as lack of jurisdiction, second is defect in the complaint or information, third, double jeopardy. The effects of a plea. First is guilty. Plea waives the right to trial. The court proceeds to sentencing. Number 2, not guilty. Plea the case goes to trial where the prosecution must prove guilt beyond a reasonable doubt. In plea bargaining in Section 4, the accused may plead guilty to lesser offense ed. The court and the prosecution approve. The lesser offense is included in the original charge. The importance of arraignment and plea. First is to ensure due process, confirms the accused knows and understands the charges. Number 2, sets the case direction, determines whether the case will go to trial or proceed to sentencing. And the third is protects the rights, guarantees the accused right to defend themselves and have legal representation. Happens after arraignment. If the accused pleads not guilty, the case proceeds to pre-trial and trial. If the accused pleads guilty, the court may impose a sentence immediately, depending on the circumstances. Rule 117 of the revised Rules of Criminal Procedure in the Philippines governs the motion to quash an information or complaint. A motion to quash is a legal remedy used by the accused to challenge the sufficiency or validity of a criminal complaint or information before entering a plea. Grounds for a motion to quash. In Section 3, Rule 117, the accused may file a motion to quash based on any of the following grounds. The first is lack of jurisdiction over the offense. The court does not have the authority to hear and decide the criminal case. And the second, lack of jurisdiction over the persons of the accused. The accused was not properly subjected to the court's authority. And the third is the offense charged does not constitute a crime. The facts alleged thus amount to a criminal. Number 4, there is double jeopardy. The accused is being prosecuted again for the offense for which they have already been convicted or acquitted. And the fifth, the facts charged do not show that the offense was committed within the jurisdiction of the court. And the sixth, the accused has been guaranteed immunity. The prosecution is barred because the accused has immunity from the prosecution. Number 7, the information does not conform to the prescribed form. The criminal complaint or information is defective in form or substance. Number 8, lack of authorization. The officer who filed the information did not appear the authority to do so. And number 9, another case is pending. There is another criminal case involving the same offense against the same accused. And number 10, the criminal action or liability has been extinguished. The crime is no longer punishable due to amnesty, prescription, or other lawful causes. 11. The accused's right to speedy trial was violated. Filing and hearing of motion. A motion to quash must be filed before the accused enters a plea. Once the plea is entered, the motion to quash is generally waived. except for grounds such as lack of jurisdiction. The court will hear arguments from the both and prosecution and defense to determine whether the motion is valid. Effects of granting the motion to quash. First is the dismissal of the case. If the motion is granted on grounds that terminate the case, for example, lack of jurisdiction of double jeopardy, the case is dismissed. And the second is amendment of the complaint or information. If the defect can be corrected, for example, efficiency of form, the prosecution may amend the information and refile the case. Exception, no waiver or of certain grounds. Some grounds, such as lack of jurisdiction and double jeopardy, are not waived even if the accused proceeds to trial without a filing motion to quash. The motion to quash is a crucial procedural remedy that allows the accused to assert their rights early in the proceedings. It serves to prevent unnecessary trials if there are legal grounds to dismiss the case outright. However, it requires precise timing and a strong legal basis to be successful. Rule 118 of the Rules of Criminal Procedure in the Philippines govern pre-trial in criminal cases. The pre-trial stage is a procedural step intended to simplify the trial process, identify issues, and facilitate agreements between the prosecution and the defense. The purpose of pre-trial. The primary objective of pre-trial is to streamline criminal proceedings and avoid unnecessary delays. It promotes the following. First is efficiency in proceeding. Eliminates frivolous or irrelevant matters. Second, clarity of issues. Identify the facts or legal issues in dispute. Third, facilitation of agreements. Encourage stipulations of facts and admissions to shorten the trial. Fourth, promotion of plea bargaining. Enables parties to explore plea options. Fifth, modification of charges. This may involve amending the complaint or information. Sixth, referral to mediation, if allowed. In special cases, the court may direct the parties to explore settlement options through mediation. 7. Other matters for a fair trial. Any issue that could aid in the resolution of the case or reduce the length of trial. Pre-trial order in Section 2, Rule 118. After the pre-trial, the court issues a pre-trial order, summarizing the agreements reached and specifying the issues for trial. This serves as a binding framework for the proceedings and ensures that the trial remains focused. The importance of pre-trial in criminal cases. First is judicial efficiency. By narrowing down the issues and stipulating facts, pre-trial reduces the time and resources spent on lengthy litigation. The second is protection of the accused. Ensure transparency in the trial process and prevents surprises during the trial. Third, promotes fairness. Offers an opportunity for both parties to clarify their positions and prepare adequately for trial. Fourth, encourages settlement. Facilitates plea bargaining and other agreements that could resolve the case without proceeding to trial. Consequences of failure to appear. If the prosecution or the defense fails to appear at the pre-trial conference without a valid reason, sanctions may be imposed, including dismissal of the case. If the prosecution is absent or proceeding in the absence of the accused or counsel, if the defense is absent, the pre-trial in relation to the Speedy Trial Act under the Speedy Trial Act, RA 8493 and related jurisprudence, pre-trial must be conducted promptly to uphold the accused's right to a speedy trial. Delays at this stage may result in sanctions against either party or dismissal of the case if rights are violated. Pre-trial is a critical phase in criminal proceeding that seeks to expedite the trial process, protect the rights of the accused, and promote justice. It is mandatory for courts to conduct pre-trial conferences in criminal cases to ensure efficient and fair resolution. 119 of the Revised Rules of Criminal Procedure governs the trial phase in criminal cases in the Philippines. The trial stage where the prosecution and defense their evidence and and arguments before the court to establish the guilty or innocence of the accused. The trial in Section 1, Rule 119, the trial is conducted to first is determine whether the accused is guilty or not guilty of the offense charged. Second, protect the constitutional rights of the accused to offer an impartial trial. The trial must be conducted expeditiously with observance of due process and within the periods prescribed by the Speedy Trial Act RE 8493. Order of Trial, Section 2 of Rule 119, the trial follows a specific consequences unless the court for good reasons directs otherwise. First is prosecution evidence in chief. The prosecution presents its evidence to prove the guilt of the accused beyond reasonable doubt. Witnesses are called for direct examination, and the defense may cross-examine. And second, demurrer to evidence, optional. After the prosecution rests, the defense may file a demurrer to evidence, arguing that the prosecution's evidence is insufficient to convict. If granted, the case is dismissed. And third, defense evidence. The defense presents its evidence to rebut the prosecution's case or establish the innocence of the accused. And fourth, rebuttal and rebuttal evidence, if necessary. The prosecution may present rebuttal evidence, and the defense may respond with a rebuttal evidence to address new issues raised. Fifth, closing arguments, optional. Both parties may present oral or written arguments summarizing their case and evidence. Number 6, submission of the case for decision. The court evaluates the evidence and arguments and renders a decision. Trial in absentia in Section 3, Rule 119, a trial may proceed without the accused if first is the accused has been arraigned. Second, the accused was duly notified of the trial schedule. Third, the accused fails to appear without justifiable cause. This provision prevents undue delays caused by the accused's absence. Continuous trial in Section 4, 119. To promote judicial efficiency, trial must proceed continuously and as quickly as possible. First, initial presentation of evidence. Trial must start within 30 days from that pre-trial order. And second, daily hearings. Trial must be held daily unless impracticable. Third, completion. The entire trial should be completed within 180 days from the start. Demurrer to evidence in Section 23, Rule 119, prosecution rests its case. The defense may move for a demurrer to evidence without presenting its own evidence. This challenges the efficiency of the prosecution's evidence to convict. If granted, the case is dismissed and the accused is acquitted. If denied, the defense presents its evidence. Right of the accused during trial. The accused enjoys the following constitutional rights during trial. First, presumption of innocence. The burden of proof lies with the prosecution. Second, right to be heard. Accused can testify, present evidence, and cross-examination witnesses. Safeguard against delays. Continuous trials ensure justice is delivered promptly. Third, right to counsel. The accused is entitled to legal representation. Fourth, right against self-incrimination. The accused cannot be compelled to testify against themselves. And fifth, right to speedy trial. Must proceed without unnecessary delays. Prominent features of Rule 119. First, efficient case management. The rule mandates strict observance of timelines to avoid prolonged litigation. Third, protection of rights. Emphasize due process and the protection of constitutional guarantees for both the accused and the states. The implication of Rule 119. First, for the prosecution, the rule highlights the importance of building a strong case and presenting evidence effectively. Second, for the defense, provides opportunities to challenge evidence and advocate for the rights of the accused. Third, for the courts, to enforce the duty of judges to manage cases efficiently while ensuring a fair trial. Rule 119 ensures that the trial process is conducted in a manner that upholds the principles of justice, fairness, and efficiency by adhering to prescribed timelines, and procedures, it safeguards the rights of the accused while ensuring that the prosecution has a fair opportunity to present its case. Rule 120, Judgment. Judgment in Section 1. A judgment is the final determination of the court on the guilt or innocence of the accused, rendered in writing and personally signed by the presiding judge. It is based on the evidence, arguments, and applicable law. The contents of judgment in Section 2, Rule 120, every judgment must first state clearly the facts and law. The decision must specify the facts of the case and the legal basis for the court's conclusion. Second, conviction or acquittal. Clearly state whether the accused is guilty or not guilty. Third, penalty, if applicable. If the accused is convicted, the judgment must specify the penalty imposed, including imprisonment, fines, or other sanctions. And fourth, civil liability. Include any civil liability arising from the offense, such as damages to the victim. When is the judgment promulgated? Section 6, Rule 120. A judgment is promulgated by reading the decision in open court to the accused under counsel. If the accused is in custody, they must be present for promulgation. If the accused is absent and at large, the judgment is entered in the court's records, and the accused is then notified. Judgment in case of acquittal if the accused is acquitted. First is the judgment must declare that the evidence failed to prove guilty beyond reasonable doubt. And the second is the accused is released from custody unless detained for another lawful reason. Third, any bond posted by the accused is cancelled. Judgment in case of conviction. If the accused is convicted, first is the judgment must specify the offense, the penalty imposed, and any civil liability. Second, the accused is taken into custody unless bail is allowed and posted for appeal. Third, the court may consider mitigating, aggravating, or alternative circumstances in determining the penalty. The modification of judgment, Section 7, Rule 120, the court may modify the judgment first before finality. The court has the power to alter the judgment for clerical errors or consider newly discovered evidence. Second, after finality, modifications are generally not allowed except for cases where the judgment is void or involves clerical mistakes. The double jeopardy consideration, Section 11, Rule 120, once a judgment becomes final, the accused cannot be tried again for the same offense, ensuring the constitutional rights against double jeopardy. The effects of judgment on civil liability. First is acquittal. The civil liability is extinguished if the acquittal is based on the fact that the accused did not commit the offense. However, if the acquittal is based on reasonable doubt, the accused may still be held liable in a separate civil action. Second, conviction. The judgment includes civil liability unless a separate civil case is filed. Execution of judgment. First, if convicted, the court issue a warrant of commitment to enforce the penalty. Second, if acquitted, the accused is released immediately unless held for another legal reason. The principles of under Rule 120, first is finality of judgment. Once a judgment becomes final, it is inclusive and binding. Second, due process. Judgment must be based solely on the evidence presented during the trial. Third, fair and impartial justice. The judgment must reflect an unbiased application of the law. The implications of Rule 120, first is for the accused. The judgment determines their fate and should be based on a fair evaluation of evidence. Second, for the victim. The judgment may provide a sense of justice and determine any separations. And third, for the court. The decision must be clear, logical, and legally sound to withstand scrutiny on appeal. Rule 120 underscores the importance of delivering clear, impartial, and legally grounded judgments in criminal cases. It ensures that justice is served both for the accused and the victims while safeguarding constitutional rights. Rule 121 of the Revised Rules of Criminal Procedure governs motion for a new trial or reconsideration in criminal cases. These remedies allows a party, usually the accused, to seek a re-evaluation of the case after judgment, but before the judgment becomes final and executory. The purpose of Rule 121 is to first is correct errors, address any errors of fact or law in trial or judgment. Second, to ensure justice, allow presentation of newly discovered evidence or rectify any miscarriage of justice. Third, provide due process, ensure the accused receive a fair trial by revisiting aspects of the case that may have been overlooked or misjudged. The grounds for new trial, Section 2, Rule 121, a new trial may be granted the following grounds. First, error during trial. Errors of the law or irregularities prejudicial to the substantial rights of the accused. Example, include improper admission or exclusion of evidence, bias or procedural lapses. Second, newly discovered evidence. Evidence discovered after the trial and could not have been produced during the trial, despite due diligence. The evidence must be material and likely to change the outcome of the case. The grounds for reconsideration, Section 3, Rule 121, a motion for reconsideration may be filed based on, first, error of law or fact, allegation that the judgment is contrary to the evidence presented or the applicable law. Second, misappreciation of evidence, claims that the court misunderstood or overlooked key evidence. Filing the motion, Section 1, Rule 121. The motion for a new trial or reconsideration must be filed before the judgment becomes final and executory. It should specify the grounds relied upon and include affidavits or evidence supporting the motion, if based on newly discovered evidence. The effect of filing the motion in Section 5, Rule 121, the filing of a motion for a new trial or reconsideration suspends the finality of the judgment. The court cannot enforce the judgment until the motion is resolved. The court's ruling on the motion, Section 4, Rule 121, the court may first is deny the motion if the grounds are insufficient or lack merit, and second, grant a new trial if errors or newly discovered evidence justify reopening the case. Third, grant reconsideration if the judgment is found to be erroneous or unjust. Effects of granting a trial in Section 6, Rule 121, the first is reopening the case. The case is reopened and parties may present additional evidence. Second, nullification of the original judgment. The original judgment is set aside. Third, proceeding de novo. The trial proceeds as if no judgment had been rendered. The effects of granting reconsideration of Section 7, Rule 121, amendment or reversal of judgment. The court may modify or reverse its decision. Second, no need for a new trial. Unlike a new trial, the reconsideration focuses solely on the existing evidence and legal arguments. The considerations of Rule 121. First is timeliness. The motion must be filed promptly as judgment become final and executory if no action is taken within the allowable period. Second, materiality. The ground must be substantial and likely to affect the outcome of the case. Third, judicial discretion. Granting or denying the motion lies within the discretion of the court, provided it acts within the bounds of law. The practical implications. First, for the accused, Rule 121 provides a chance to rectify errors or introduce critical evidence, offering another opportunity for justice. Second, for the prosecution, it ensures fairness by allowing review of potential errors that might have led to acquittal or insufficient penalties. Third, for the judiciary, it safeguards the integrity of judicial proceedings by ensuring decisions accurate and justice. Rule 121 is a crucial procedural safeguard that ensures fairness and justice in criminal cases. by providing avenues for new trials or reconsideration. It balances the need for finality in judgments within the right of the accused to the due process and a fair trial. Rule 126 of the Revised Rules of Criminal Procedures in the Philippines governs search and seizure, outlining the legal procedures for law enforcement officers to search and seize properly in criminal investigations. This rule ensures that the constitutional rights of the individuals are respected while allowing the authorities to gather evidence. The provisions of Rule 126. First is search with a warrant. In Section 1, a search may only be conducted with a valid search warrant issued by a judge based on probable cause. The warrant must specify the place to be searched and the items to be seized. The warrant must be supported by an affidavit stating that the facts that justify the search. Second, search without a warrant in Section 2. In certain situations, law enforcement officers may conduct a search without a warrant, such as when an offense is committed in the presence of the officer in flagrante delicto, when an arrest has been made and the search is related to the arrest, when there is a hot pursuit and evidence is likely to be destroyed, if not immediately seized, when the search is conducted, in case where when the law allows it, such as customs enforcement or border searches. Third, procedure for search, Section 3. The search must be conducted in the presence of the accused, and the person conducted. The search must issue the search warrant if applicable, and ensure the search is conducted in a reasonable manner, and items seized must be described in the warrant. Provide a recipient of the items seized to be persons from the whom they were taken. Fourth, seizures of property, Section 7. Law enforcement officer may seize items found during a lawful search that are contraband or evidence of a crime, even if were not listed in the warrant. If the items are not immediately disposed of in accordance with the law, they must be preserved and submitted to the court. Fifth, return of search warrant in Section 5. A return of a warrant must be made to the issuing judge, stating what was seized and when the search was conducted. The importance of Rule 126, protection of rights. It ensures that the search and seizures are conducted in a manner that respect the individual's right to privacy and protects against unreasonable searches as guaranteed by the Constitution. Due process. The rule mandates that searches are only done with proper legal authority, ensuring that evidence obtained in violation of the law is inadmissible in court. Law enforcement. It provides law enforcement with a legal framework to gather evidence effectively while preventing abuse and overreach in criminal investigations. In Rule 126, it strikes a balance between empowering law enforcement and safeguarding citizens' constitutional rights, ensuring that searches and seizures are done lawfully and justly.